All right. Good night, I guess, right now. I can't believe that it's 11:33 on Christmas Eve and I'm doing a video. But Delete Lawz has given us all a wonderful Christmas gift. The gift of laughter at him. Um so I'm going to jump right into it because, like I said, it is Christmas Eve. Had a successful Christmas Eve party with the family. It was busy, it was loud, not too much damage. No one went home in tears, so it was a success. But so Merry Christmas. Thanks for joining. Please like, share, subscribe, do all that jazz. And let's jump in. So if you remember, let's go to the docket. Some time ago, Delete Lawz on November 14th entered an emergency motion for contempt because he didn't like the chilly as a quarter of a man video that Kate did. And there are some transcripts of status conferences that I haven't seen. I'm not going to pay for them on Pacer, so I'd only be guessing what's in them. 14 days later, Kate filed opposition regarding entry 61, emergency motion for contempt filed by Kate Peter, in which she opposed the motion for contempt and said, pulled an Uno reverse card and said, but I think you're in contempt. And on December 1st, docket number 78, Judge Burroughs denied both motions for contempt and said, in the court's view, both parties have repeatedly engaged in inappropriate behavior towards one another, and the court will not single out one party for punishment where both are at fault. The parties are once again reminded that this is a court and not a kindergarten, and that the court expects the parties to act accordingly. So, on December 9th, Delete Lawz filed a motion for leave to file a reply to Kate's motion for contempt, which had already been rejected. The court did not find him in contempt, but he still wanted to argue about it. And the court granted him leave for whatever reason. And so this dropped on our laps today. And you'll notice as we get into it, it's not actually an opposition to Kate's motion to hold him in contempt. It's more of a renewed motion asking, well, pretty please hold her in contempt. So let's jump into it. Plaintiff's reply to defendant Peter's opposition to motion for sanctions. Plaintiff Jose de Castro offers the following reply to the opposition memorandum from defendant Catherine Peters, ECF number 71, of plaintiff's motion for sanctions, ECF number 61. Since I outlined the legal authority in my original motion, such information is not repeated here, and I do not intend by its omission from discussion here to concede to any point previously raised related to contempt for violation of a court order. However, Peter and her attorney of record have also participated in Rule 11 sanctionable activity in their opposition brief. Spoiler alert, they haven't. And I mean, for all the time he's spent typing, well, I already laid all this out in my previous motion, so I'm not going to do it here anyways, but I still want you to consider it. You could have just copied and pasted. So, Section A, Rule 11, Sanctionable Activity. Now, Rule 11 is a big fun rule. In my civil procedure class, first day, our professor selected someone as Mr. Rule 11. Long before we even covered Rule 11. And anytime something related to Rule 11 came up, whether it was by him or by a question asked by someone in the class, he'd turn to him and said, "Carl, what's this?" And he'd say, "Rule 11. So, Federal Rule of Civil Procedure 11B1 says that when a party presents to the court a pleading, written motion, or other paper that is not being presented for any improper purpose. So, sometimes the English language is hard. This sentence just, it seems like it's a double negative the way it's written. So, Rule 11 says that when a party presents to the court a pleading, written motion, or other paper, that he should have written, it cannot be presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. That is what the rule says. He doesn't understand the application of the rule, but we'll get to that in a minute. Although directed by this court to respond to my motion for contempt with a request for the shortening of time sooner rather than later, Peter and her counsel responded exactly 14 days after my motion for contempt was filed, delaying this court. So, that is utter nonsense. Both because of the application of Rule 11, but also because of Rule 12. So, Rule 11 from the Federal Rules of Civil Procedure, like I said, is a nice long rule. Section A is about the signatures needed on pleadings. Rule B is the representations to the court. Rule C, or Rule 11C, is sanctions. And then D is the inapplicability of this to discovery. So, 11B1, well, 11B generally says, by presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, 1, it is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. So, first and foremost, he's saying, well, they didn't file this fast enough, so you need to sanction them under Rule 11. Well, that's not what this says. It says you can't be filing it for the purpose of causing needless delay or expense or whatever. So, delete Lawz constantly filing frivolous motions for sanctions could be sanctionable under Rule 11. At some point, Judge Burroughs probably will at least warn him, hey, stop this or else. His 6 motions to get her to reconsider the voluntary dismissal, that's how is that not increasing the cost of litigation and causing delay, and it's asinine. But even still, let's look at the Rule 11C, sanctions. Number one, in general, if after notice, that's an important part, after notice and a reasonable opportunity to respond, the court determines that Rule 11B has been violated, the court may impose an appropriate sanction on any attorney, law firm, or party that violated the rule. And then C2 says, a motion for sanctions must be made separately from any other motion and must describe the specific conduct that allegedly violates Rule 11B. It has to be served, and then C3, a court can bring it sua sponte on its own volition. And so what that means, C1, if after notice. So you have to go to the opposing party and say, hey, I think you're engaged in sanctionable activity. You need to stop. If you have not stopped within a reasonable opportunity to stop, I'm going to bring a motion for sanctions. Has he done that here? I doubt it. I very highly doubt it. But like I said, even if Mr. Wish was late in filing his motion for Kate, it would never be a Rule 11 violation. But let's go back to the motion, though. He says, although directed by this court to respond to my motion for contempt with a request for shortening of time sooner rather than later, Peter and her counsel responded exactly 14 days after my motion for contempt was filed, delaying this court. Now, first off, I have not seen anything in the docket where Judge Burroughs set a deadline for responding. So if this sooner rather than sooner rather than later language is anywhere, it's in the transcript of the summary conference, which I'm not going to pay for on Pacer because it'll just be boring and I'm cheap. But what does sooner rather than later mean? I don't know. Mr. Wish couldn't have known it. So it's vague, and vague orders, how do you follow them? Well, you probably default to the rules of civil procedure or other local rules. So let's look at Rule 12. If you remember, we spent a lot of time on Rule 12 on the last two videos, but we were discussing Rule 12B and the motions to dismiss. Rule 12A is the time to serve a responsive pleading. So 12A 4 says, remember, this is time to serve a responsive pleading, effect of a motion, unless the court sets a different time, and sooner rather than later is not setting a different time. So unless the court sets a different time, serving a motion under this rule alter these periods as follows. If the court denies a motion or postpones its disposition, it's 14 days. If the court grants a motion, 14 days. So basically, they had 14 days after Lawz filed his motion to contempt to file a responsive pleading. Now, that's if they even needed to file a responsive pleading. I mean, his motion for contempt was laughable. I don't think they needed a responsive pleading anyway. I mean, look at theirs. The judge denied both of them before he responded to theirs. A responsive pleading wasn't needed, but they filed a responsive pleading anyway 14 days later, which is what the rule says they can. How do you get sanctions from following the rules? I mean, I don't know. But, you know, Mr. Galaxy Brain clearly knows better than Mr. Wish. So, he continues, Peter and her counsel also impeached themselves in the response, delaying justice for their offenses. Remember how we discussed conclusory statements? That's what's known as a conclusory statement. What did they impeach themselves? What was contradictory? What? I seriously don't know. He's not put them on notice. He hasn't put the court on notice. It's not even worth responding. But Peter and her counsel also attributed a quote to me as a title in their pleading, not as evidence, but only in a way to harass or prejudice the court. Well, first off, they're not harassing the court. They absolutely are trying to prejudice the court. And he tries to claim, well, it's not attributed. I don't remember if it was cited or not. I remember seeing the video, and it's an exact quote from my memory. But he says, it was not properly introduced. No one declared who or when the evidence was collected, who transcribed it, or the date of the video that it was taken from. Mr. Wish transcribed it. Saying all he has to do is put the URL and a timestamp. There's the quote. There. I mean, but he claims it was not accurately transcribed, nor entered under the penalty of perjury as part of a pleading. Mr. Wish isn't entering anything under penalty of perjury. It wasn't an affidavit. It was a motion. Peter allegedly quotes me in a YouTube video. Yeah, it is a quote. Saying, I will break them financially. They will have to hire a lawyer. I will file a motion after motion after, and I'll just keep going legally after them until I break them, until they can't afford to hire a lawyer anymore. So they run out of money. That's what I'm going to do. I'm going to break them. So, you know how I've said, every time Mr. Garrick for Josh has repeated this quote, I say, keep repeating it. Every time the judge hears it, it prejudices her against him. And this moron puts it in his own motion so that she sees it again. That's a galaxy brain move there. But he says, not only is this transcription not accurate, but the YouTube video is irrelevant to this case and obviously. That's the whole sentence, and obviously. I mean, that YouTube video exists. It's as accurate a transcription as I could do. I've seen the video multiple times. I'm not going to go searching for it to play it because I just don't care that much. It's out there. But even though it's not the subject of this litigation, if he's talking about the litigation and his ulterior motives, that's very relevant, especially to a sanctions motion. It's relevant to a motion to dismiss with prejudice. It's relevant. But I did previously warn Peter by email of the costs of litigation and damages for defamation to have her retract her defamatory video of me as outlined with evidence in the preliminary injunction request in ECF number 59. Yeah, and you also made a video where you made this statement. She has admitted in her YouTube videos to spending over $52,000 in legal fees to defend herself in this action, proving me right. And I've made no oh, this is laughable. I've made no frivolous pleadings, written motions, or other papers in this court proceeding. Instead, she, with her counsel, has done it multiple times. Time out. You making the same motion 6 times is frivolous. You, when Mr. Wish emailed you saying, hey, I understand you're going to file an amended complaint. Will you please file it so we can file our answer to that? And his response was, you're not my daddy. You can't tell me what to do. You've got to follow my rules because we're going to do this exactly. And then changes the cause of action. That was clearly done to cause delay and harass and raise expenses. I mean, what other reason is there? I mean, adding a cause of action, sure. Fixing your pleadings, sure. Completely changing it so they don't know what the hell they're defending? That's frivolous litigation right there. And he says, and instead, she with her counsel has done it multiple times. Where? What frivolous motions have they filed? Name one. Name just one. You say she's done it multiple times. Name one. You don't hear. You just add this conclusory statement. But in section B, he says, allegations of plaintiff filing court documents to harass. Yes. You have been filing court documents to harass. Much of Peter's opposition to my motion for contempt revolve around arguments that I am filing court documents to harass her. Yes. Since my motion for contempt related to this court's orders against harassment outside of the courtroom, her arguments and irrelevant and incorrectly transcribed quotes about my exercising my right to seek judicial relief are simply that, irrelevant, and should be stricken from her response. I mean, arguing about it right here is irrelevant. The judge already denied it. I mean, and he says, additionally, this court has ruled on most of my serial motions without a response from the defendants, but it's still dragging things out. It's still costing the court time. It's costing the taxpayers money. Mr. Wish is still reading every one of these. It would be malpractice if he didn't. It is still harassing. It is still time consuming. It still costs money. And like I said, he was given leave to respond. But from here on, it's him saying, well, pretty please put her in contempt. And here he complains about the Discord server. Section C, Peter's Discord server. Peter admits to operating a Discord server with 2,800 users, admits to having only recently posted rules for the server, and proves that those rules aren't being enforced. I don't remember her admitting to only recently posting rules. She has always had rules as far as I know. And once again, this at this moment is a copyright case. Kate is not responsible for what anyone else posts on Discord. If you don't like what other people write, sue them. It's that simple. He says, Peter admits to the screenshots that I introduced as evidence as being made on her server, but she did not make them. She didn't make them, which violates the rules that she posted. Where? How do they violate the rules? They don't. There are no rules that people can't talk about you. But Peter has proven that the rules are posted simply as a facade. Peter makes Peter makes conclusory statements that she is not responsible for the actions of other users. I mean, she's not responsible for the actions of other people. That's something that I mean, she doesn't need more than a conclusory statement for that. I mean, when something's that obvious, it barely bears mentioning. I mean, if he thinks that she's responsible, you bring more than a conclusory statement. You bring evidence. You bring the law. You haven't. And he said, but under the doctrine of agency, which she is ignorant of, she is wholly responsible. Good God, man. The doctrine of agency. She has no agency relationship. I mean, if there's any agency relationship, it would be, and even here, I don't think there is, but it would be with Shiz when Shiz is appearing on the Masshole live streams. But Shiz posting on Discord, even on the Masshole Discord server, she's doing it as herself. She's not an agent of anyone. If I post, I'm not an agent of anyone. Just hosting a Discord server does not create an agency relationship. This is laughable. It's so absurd. And I get it. Agency is a difficult subject. Like, more so than you'd realize. Like, the business associations class can get really complex in law school because, under agency, is there apparent authority? Is there implied authority? Is it, it's a mess. What authority has she granted them? Even implied? None. They're not speaking for her. That's what an agency would be. They're not speaking for Kate. Period. It's not agency. Peter has admitted to tracking me on the server like a great white shark. No, she has not admitted to tracking you. She said on her video, on the Memorial Day video, that you were that she was tracking him like a great white shark. It was hyperbole. It was to take that seriously. You have to be a mental midget. It's just asinine. But Peter has admitted to tracking me on the server like a great white shark, including the actions of her and her 2,800 trolls always tracking my physical location. They're not tracking you, you idiot. You are streaming and showing street signs. You're showing businesses. You are showing your location. It's not tracking you to say, hey, he was at this street corner. Isn't that cool? That's not tracking you. That's not illegal. And once again, Kate is not the one doing that. She is not responsible if other people post that. She's not. I submitted as evidence screenshots from messages on her server that obviously violate her recently posted rules, yet the behavior remains and is used to target whoever Ms. Peter is currently interested in targeting. Once again, okay. Are you suing her for violating the rules of her Discord server? No? Then what bearing does the rules on her Discord server even have in this? None? Exactly. As evidence of the misbehavior and her culpability, Peter has also recently finally archived the channel on her Discord server designed specifically to track me, named Chili Watch. It's not to track you, you imbecile. It's to make fun of you. And I sure hope you've archived Chili's backup. While I initially appreciated Peter finally taking action, it was done for more nefarious purposes. Okay. That specific Discord channel is no longer used to harass me and my associates, but the coordination of attacks is still being made, apparently on a different platform. What platform? Where is it? What evidence do you have? None? I'm shocked. I mean, is it that wicker or whatever the hell it was that you were alleging? I mean, you brought no evidence of it, but yeah, let's sanction her with no evidence. Videos made by Peter and her trolls continue to often mention a wealth of common location and other data being collected and shared on me and my associates, obviously on a new platform with a better kept secret location. Is it obvious though? I mean, I certainly don't know of any other location. Not that I'm active on her Discord. I don't care where he is. But once again, your location is obvious. You broadcast your location constantly, and you have brought no evidence of any kind about this alleged new and better platform that's totally secret, but you clearly know about even though you don't know where it is. That's asinine. Allegations of plaintiff doxing trolls. Yeah. You went on a clearly altered state rant. I'm going to dox them. I'm going to dox their families. I'm going to dox their jobs. I'm going to get them all fired. Peter says that well, hang on. You say allegations of plaintiff doxing trolls. You're the plaintiff, delete Lawz. There are allegations of you doxing. But here you're talking about the defendant, about Peter, about Kate, and her supposed doxing. Peter says that she did not harass or dox my associates, i.e., publicly identify him by name, address, and or other personal information. Under her own and once again, this is unhinged of him. The supposed associate was never doxed to my knowledge, but under her own definition, I have not doxed Todd Lyons. Publicly identify him by name. You dropped the name Todd Lyons. Whether that's a true name or not, I don't know. I don't know who Todd Lyons actually is. I don't know if it's one of your fever dreams where you make up evidence. I don't know if it is a troll. I don't know anything about Todd Lyons. But if I'm to take you at your word on that video, you doxed him. I did not provide the address of any trolls. But you said her definition, publicly identify him by name, address, and or other personal information. His name, that's one of the ors. Even if I did, I don't run a troll farm. So first off, Kate does not run a troll farm. A troll farm is organized. It's going to have an actual hierarchy. They're actually going to be employed. It's going to be a cohesive organization with a specific target. This is not a troll farm. But once again, if the supposed troll farm, if everyone posting in Kate's Discord, if Kate is responsible for all of them, is he not responsible for Jeff Hates Pigs, for Chevy, for Gloria, for that moron in Nye County? You have rights, cops have duties. What is he not responsible when he gives the Vegas Valley Blue Bacon's information, knowing he wants to show up at Blue Bacon's house to do violence? Is the way he said it. Shouldn't he be responsible for them under that same theory? I would think, but I don't. Even if I did, I don't run a troll farm that will then harass and vandalize that person's property. What vandalism? The Nutella? That who's been harassed? I mean, the Zaner in New Hampshire that no one even knew where that was. That I mean, okay. I don't run a troll farm that result in them and their family and employer being harassed endlessly by telephone, email, online, and in person. First off, who has done this harassing? You claim it's happened. We haven't seen any receipts. You haven't provided receipts to the court, and you are the one who is in video after video threatening to do exactly this, to contact their family, to get them harassed, get them fired. Kate's mother has been called, although I don't know if it was him. I can't remember. But I mean, talk about dirty hands. I am only interested only in removing a troll's veil of anonymity, which would be doxing, you moron. I mean, he is the stupidest person on the planet. For example, to let their mother know of the illegal behavior that they are doing. So you say, I don't run a troll farm that will result in them and their family being harassed endlessly by telephone. The next line, for example, to let their mother know, presumably by calling and harassing her. And what illegal behavior are they doing? And once again, how is that Kate? You're suing Kate. If the troll is doing something illegal, call the cops on them, not Kate. This is not harassment and is actually the natural consequences that we learn in elementary school that results from bad behavior, as mentioned in this court's order at ECF number 50. Once again, that is not Kate. It's not Kate. And once again, it's not harassment. It's the natural consequences. You getting trolled mercilessly is the natural consequence of acting as a clown on YouTube, spouting law that you know nothing about, interfering in court, filing frivolous lawsuits. This is the natural consequence. Additionally, Peter continues to allege that I'm partaking in threats of public exposure in exchange for affidavits, which we know isn't true, as she can offer no evidence. But as far as serial repetition of allegations to waste this court's time, this qualifies. As far as I know, I haven't seen it, but it's my understanding that there are affidavits filed saying, yeah, he's trying to strong arm me into writing a false affidavit for him. That would be evidence. Poking holes in the anonymity of online criminals is not the same as harassing members of my legal team who are doing nothing wrong. Well, for starters, you're pro se. You don't have a legal team. If you do have a legal team, they either are engaged in the unauthorized practice of law because they're not lawyers, or they're most likely engaged in the unauthorized practice of law since they're not lawyers in Massachusetts. And if they're writing motions for you, this one is clearly delete Lawz. It's incoherent rambling that I would guess is aided at the very least by Adderall, if not a stronger stimulant. But If they're writing your motions and not signing them, that is also unethical. That's not allowed. I mean, but once again, let's say you do have a legal team. They are, in this case, the alleged trolls are not. So why do you keep bringing them up? They're irrelevant. And once again, let's go back to the "you're not my daddy" voicemail. If you don't want your legal team harassed, why have you harassed Benjamin Wish? Serious question. Why have you harassed Benjamin Wish? My legal team aren't afraid that their mothers or employers find out what they're doing. They should be. My God, it exposes them as morons. They're afraid of the telephone calls, emails, vandalism, and other constant harassment to them, their families, and their employers that follows being doxed by a troll farm. Who's your legal team? I mean, discussing Lawz. He opens himself up by running a YouTube channel, slobbing your knob. Who else is on your legal team? I haven't seen anything. I mean, I'm not the most connected, but I haven't seen anything. You're pro se. And I mean, they shouldn't be harassed. If you are harassing anyone, stop. Don't call them. I mean, let them wither in obscurity. They're only doing this to try to bask in the incandescent glow of delete Lawz. You know, he's irrelevant. But the harassment of my associates. Peter says Ms. Peter did publish a live stream on November 12th. That's the "Chilly is a quarter of a man" video. And in the thumbnail for the video, used an image of a man whose identity she did not know at the time. Yeah, she says, I didn't know who he was. I saw his picture somewhere, but I didn't know who he was. Indeed, he never closed that quotation, so I'm not sure if this is still a quote or him talking, but indeed, at the time Ms. Peter published the video, she understood only that this man had been entering group conference calls with her Discord server to take clandestine recordings. So you could almost say he was a member of her troll farm Discord server. How is she to know who he is or how he's connected to you? She didn't know his name. She never said, at least not on the video, hey, this is one of delete Lawz morons that's been bugging our Discord voice chats. She just put his public picture. Is that illegal? Not that I know of. She did not know that this person was in any way affiliated with Mr. DeCastro. Peter knows that she did not own the copyright to the image that she used. Okay. That is, once again, moronic. For starters, you don't own the copyright. So you can't complain about the copyright. It's irrelevant for this case. But once again, the way she used it on her thumbnail was clearly fair use. She admits to having done it to give him a little nod as a joke, a prank, as you will, which may not rise to the legal definition of a series of such offenses, but certainly was in violation of this court's orders against harassment, especially given the language used at the hearing on October 24th, ECF number 68, and all its orders against harassment and inappropriate behavior. But once again, she wasn't harassing you. She didn't know who he was. It was someone engaged on her Discord server. Is she supposed to inquire about her relationship to you before she does anything? I mean, if she had, then you'd say, she's trying to find out who my legal team is. How dare she? But he says, Peter has also perjured herself in making the above statement. Did she? When Adams, who is Adams? Who's Adams? Is Adams the person whose picture she used? I mean, you suddenly introduce this character named Adams. Who is Adams? But when Adams collected information from Peter's Discord server, he used his real name and posted in each channel on the Discord server that he had just scraped the data for use in this pending legal action on my behalf. Have you tried reading Kate's Discord server? By the time you read 2 posts, there's 15 new ones posted. If Kate were trying to read every single post, she wouldn't have time in the day. Not for a full-time job, not to make videos. It would be a full-time job in and of itself. Unless you have some sort of screen reader that can prove that she read this, you can say, well, she was put on notice. That doesn't mean she saw it. He also stayed to answer questions. Did Kate ask him questions? You don't say. In no way would that be considered clandestine, and Adams made it clear that he was working for me. Once again, if Kate didn't see it, she wouldn't know. If she just saw, hey, there's this random person joining the voice calls that the trolls keep emailing Adams saying that I doxed him when I put his email address in one of my filings. Once again, you are the one who provided his email. Kate did not. Kate did not post about him that I saw. She did not say whose photo that was that I saw on the video. To me, it was a random person. That is not harassment. That is not illegal. It wasn't a secret that he was on my team, as mentioned previously. Okay. Once again, you remember the minute Kate hired Benjamin Wish, you made a video saying, here's Benjamin Wish's Firm, this is his email address. This is his phone number. This is all public information, so but you putting your legal team's email in a court filing is Kate's fault if someone else contacts him. How? I don't understand how this guy logics. Adams had also signed his name to several court documents for me in other legal filings that are public record. He certainly hasn't signed anything that I've seen in this case. And unless he's a lawyer, that's going to be problematic for him. It's just that my putting Adam's personal email address in one of my filings that the trolls took notice and started harassing him. Peter is outright lying when she says that she didn't know who Adams was or that he was working for me until my motion for contempt. Peter and her troll farm have had numerous discussions on every member of my team prior to her direct harassment and the harassment of her troll farm of them. Where are these discussions then, you moron? If you don't provide these discussions, they didn't happen. They didn't happen. Since then, Adams has had threats not to participate in this action, along with threats toward his young daughter. Adams has also clearly been doxed and has been told that he has been doxed hard by members of the troll farm. Doxed hard to over 2,800 trolls. What the hell does that even mean? Yeah. And I mean, once again, we don't know who he is other than Delete Lawz put his email address. We don't know that he has a daughter other than Delete Lawz just said he has a daughter. But he says Adams will no longer be participating because of these threats. Since this action has turned into a copyright one, and Adams, being a well-known expert for copyright claims, is he? Having his copyright research used in many court cases and being written up in at least one law journal on copyright law, it is impossible for me to continue. Additionally, the evidence that he collected is no longer of value without his testimony. Okay. Once again, how did Kate do this? How did Kate tamper? If someone else tampered with your witnesses, call the police. Have them arrested for witness tampering. That is not Kate. And I mean, press X to doubt that he has an expert on his team. And if he was going to testify as an expert witness, he shouldn't be part of the legal team. That's just asinine. But further contempt by Peter. On December 14th, 2022, Peter created a poll on her Discord server. The question in the poll was, should I do something dumb and self-sabotaging on YouTube out of boredom and woe and release a chilly video? once again, the court has not ordered her not to talk about Chili. If they were ordered not to talk about each other, he has made at least 10 times, if not 100 times, more videos about her since litigation commenced than she has made about him. So talk about unclean hands once again. It's ridiculous. But see Exhibit 1. Let's look at Exhibit 1. Says, should I do something dumb? And yeah. So, Exhibit 1, which I collected from Peter's Discord server on December 21st, 2022, and is a true and correct copy. Even though 176 trolls voted no and only 59 trolls voted yes, Peter did it anyway, in contempt of this court. Once again, well, first off, are you trying to allege that the poll was binding in some way? But also, the court has never entered an order saying you cannot talk about each other. You cannot make videos about each other. It said, do not harass each other. This was not harassment. On December 19th, 2022, Peter released a YouTube video titled Chili DeCastro Films His Own Arrest for Criminal Threats. Cyrax and Chili plot live on Facebook Live. See Exhibit 2, which I collected on December 20th, 2022. And the transcription is a true and correct copy. Transcription of Peter in the video below, 248 through 443. I'm about to make a retarded decision, per usual. I got this video. Nobody else has it but me and the person who sent it to me. And I found it fascinating. And we watched it together in Discord. And I was like, should I show this? And I thought about it. But here's the thing. No matter what, I'm going to get hit with bullshit litigation because it's clear abuse of process, in my opinion, at this point. Exactly. I mean, he puts it right there. Why submit to his blackmail when he's going to do it anyways? He's no matter what she does, he's going to complain to the court about it. So why not have fun with it? So I will have an announcement about the legal stuff at the end of the program. But right now, I wanted to show you guys this is actually fascinating shit. So this is a charge from 2015, actually, that Chili took it upon himself to film. The organization fee is not a crime, PNAC, and they had less than complimentary things to say about him. The members that I spoke to over that were associated with PNAC at the time, so they really weren't too impressed with this guy. This is the earliest sort of contact that I've been able to find of Chili DeCastro making any sort of even adjacent contact with the auditing community back in 2015. So this is your constitutional law scholar, everybody. This is not a copyrighted video, which inaudible. There's no protections as far as that goes. I'm always going to be adding some commentary, and I'm not going to really narrate too much what happens in this video because Chili is going to tell you in his own words. I'll just, point out what I think is interesting, and then at 3:30 or 33:21 through 26, Hillsborough Cop Watch says we don't stop. We don't even during litigation. 4108. This is just the beginning. In the video, Peter also described me as a fucking retard. That is smearing shit. That is smearing shit on the wall in reference to this lawsuit, which she has entered into because she admits that she doesn't like being told what to do, including by a court, but especially by men due to her previous abuse. She has not violated the court's orders. The court said, don't harass, don't contact. She's made videos about you. Yes, you've made dozens about her. You have gone into her comment section to harass during her videos. That is much more egregious than making a video. The video makes her contempt for this court's orders abundantly clear. No, it doesn't. Additionally, she says that the video has no copyright, showing her complete disregard for copyrights of others. I mean, she did show it in fair use. She even said, I'm going to do it in fair use. She may not have said fair use, but that's what she said. It's not registered. There's not a registered copyright. By you sending it to Hillsborough or to PNAC, it could be that you've given some sort of license to that video. And I mean, did PNAC have a license to, was it sub-licensable or, I don't know, but it was still fair use. So since the video hadn't previously been published, it was a clear violation of my copyright, and blatantly violating my copyright was further harassment and contempt of this court. Is there a court order saying don't use each other's videos? And you've sat on it for 7 years without publishing it, but you sent it to a supposed publisher, PNAC, who then sent it to Kate. So, yeah. But Peter as a serial harasser and victim blamer in contempt. Peter appeared in a YouTube video by a journalist for Turtle Boy Sports. A journalist for Turtle Boy Sports. On December 16th, 2022, where she was leaving her arraignment for continuing to troll one of her trolling victims. Okay. First off, this isn't part of this case. So how can you ask the court to hold her in contempt for it? Second, she hasn't been convicted of anything. Third, she doesn't know this person. It's Turtle Boy in his continued quest to destroy her, that he can't get a protection order against her, so he gets someone she doesn't even know to file one. And we'll see. The video where she was leaving her arraignment for continuing to troll one of her trolling victims in violation of her restraining order, saying, "Get your little victim away from me." So she's leaving the court. The supposed party that needs a protection order is following her out of court, harassing her. It would make sense for Kate to say, "Get your little victim away from me," when the little victim that needed protection from the court is the one harassing Kate outside of the court. It's asinine. But he says, see Exhibit 3, which I collected on December 23rd, 2022, and is a fair and accurate transcription. So here, under Massachusetts general laws, Chapter 233, Section 21, you would think a 20-year constitutional law scholar, such as delete Lawz, would understand the constitutional framework, and federalism. Federalism being Massachusetts is not the federal government. Massachusetts general laws, this, spoiler alert, being from the Massachusetts Rules of Evidence, is not the federal Rules of Evidence. I fail to see how the Massachusetts Rules of Evidence are of any relevance here. If delete Lawz wanted the Massachusetts Rules of Evidence to have any relevance, he should have filed in a Massachusetts state court. But he chose the venue. He chose to sue in federal court. Thus, the federal rules of evidence apply. Now, Section 21 of the Rules of Evidence for Massachusetts says is the proof of conviction of a crime to affect credibility. The conviction of a witness of a crime may be shown to affect his credibility, except as follows. First, the record of his conviction of a misdemeanor shall not be shown for such purpose after 5 years from the date on which sentence of... So, notice that says the conviction for a misdemeanor. Well, even first, it says the conviction of a witness. So, he mentions Kate leaving an arraignment. Now, remind me, I may not have paid any attention, practicing criminal law, but I do believe an arraignment happens long before a conviction. So even if the Massachusetts Rules of Evidence applied, he couldn't use this. She hasn't been convicted of anything. But fear not. Let's move on. I meant to have this pulled up already, but Christmas, so I got distracted. But let's pull up the federal Rules of Evidence. If it wants to load. So the applicable and corresponding rule of evidence would be Rule 404. Character evidence. Other crimes or acts. Character evidence. Prohibited uses. Except of a person's character or evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. Exceptions for a defendant or victim in a criminal case. Well, we're not in a criminal case. So Section A2 is irrelevant. Exceptions for a witness. Evidence of a witness's character may be admitted under Rules 608, 607, 608, and 609. So hang on. Other crimes, wrongs, or acts. So evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. The evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. So he's trying to show that Kate has a propensity for trolling, Well, under the federal rules, he can't do that. Under the Massachusetts rules, he can't do that. She hasn't been convicted of harassment. Because remember, that section required conviction. So even though it's irrelevant, it doesn't apply. And then 609 are a witness's character for truthfulness or untruthfulness, impeachment by evidence of a criminal conviction, so that's nothing, and who may impeach a witness. So 608 is the only one that might even possibly be relevant. A witness's character for truthfulness or untruthfulness. So reputation or opinion evidence. A witness's credibility may be attacked or supported by testimony about the witness's reputation for having a character for truthfulness or untruthfulness, or by testimony in the form of an opinion about that character. But evidence of truthful character is admissible only after the witness's character for truthfulness has been attacked. Well, Kate, at this point, is not a witness. That'll come up in a minute. Specific instances or conduct. Except for a criminal conviction, extrinsic evidence is not admissible to prove specific instances of a witness's conduct in order to attack or support the witness's character for truthfulness. But the court may, on cross-examination, allow them to be inquired into if they are probative for the character for truthfulness or untruthfulness. So this is just about, is Kate truthful or untruthful? Does she have a reputation of being truthful or untruthful? That's not what he's trying to bring up here. So first off, he brought up the Massachusetts rules of evidence, which are irrelevant. But under the federal rules of evidence, it wouldn't work. So he says, under the Massachusetts rule of evidence, this court should soon be able to consider Peter's recent conviction against her credibility like a... You said it was at an arraignment. She hasn't been convicted. She was leaving an arraignment. But then you say her recent conviction. Which is it? But once again, it's under the federal rules. Even if she was convicted, number one, it can't be used because it's, in order for a conviction to be used, if we had looked at Rule 609, which wasn't relevant, so I didn't click on it, it would be like a conviction for a crime of moral turpitude or fraud or theft, or that would impact her credibility. This does not impact her credibility. You're trying to use this as propensity evidence, which is not allowed. And like it should already be considering defendant Joshua Abrams' multiple felony convictions against his credibility. But once again, you're alleging violent felonies against him. Those are not crimes of dishonesty, of moral turpitude. Well, I mean, if he is convicted of rape, which you allege, which he's suing you over, that would be moral turpitude, but not of dishonesty necessarily. But once again, you're trying to use it to show he's dishonest. But also, the court should not be considering that because they are not witnesses. Witnesses are at trial. This is not anywhere near a trial. So, and he says, this evidence should also be submitted toward her pattern of harassment, especially in contempt of a court. Well, first off, she has never been held in contempt of this court. And like I said, even at trial, it can't be used to show a pattern or propensity to harass because, well, number one, you're not suing her for harassment, you're suing her for copyright infringement. So even then, you couldn't sue her, you couldn't use evidence that she has a propensity for committing copyright violations because you have to prove this copyright violation. That's why it's not allowed. You can't say, well, she did it in the past, so she probably did it this time. You have to prove it this time with evidence this time. But I mean, it's so premature, and the court will never consider this. It's the court may allow the jury to hear evidence about it eventually at trial. They won't, but you know. This is such premature ejaculation. It's ridiculous. But his conclusion, for the foregoing reasons, plaintiff requests that this court enter an order for a just cause hearing on why defendant Peter should not be found in contempt of court. Yeah, she's not going to hold a hearing on it. Everything you've put in here has been conclusory. It's not contempt. And even if it were contempt, by that standard, you're in contempt too. Enter an order for this action to be reset and heard in private. So remember up above when he said, because Kate waited 14 days to file a responsive pleading, which is what Rule 12 allows, she should be in contempt for causing undue delay, expense, wasting the court's time. Entering an order for this action to be reset. Talk about a waste of time and money. But, and heard in private. Courts are open, buddy. You're not a special case. And enter an order for the jury that plaintiff's witness was tampered with and intimidated. You haven't provided any evidence other than your own conclusory statements that that's happened. And besides which, the evidence you claim he collected on the Discord server and voice chats would be relevant to contempt, not copyright. So enter an adverse jury instruction that the witness for copyright or the witness for contempt of court isn't here, so you've got to find contempt of court jury. Well, that doesn't make any sense. And at this point, you can go hire a copyright expert if you think you need a copyright expert. There are expert witnesses out there. I highly doubt that Adams would even qualify as an expert witness. Remember, you've got to get your expert qualified. They've got to go before the court and, like, the starter testimony is laying out, this is why I'm an expert. You have, I very highly doubt he's an expert. But any other just relief that this court finds appropriate, and enter an order against Peter and her attorney of record for Rule 11 sanctions. Well, that's just a non-starter. Declaration: I declare under penalty of perjury that the foregoing is true and correct. And blah, blah, blah. Jose de Castro. Exhibit 1. Exhibit 2. That's the video she made. And Exhibit 3 is Kate getting in her car, clearly being filmed, leaving the court, well, getting to her car. It says, Kate Peter questioned by media after leaving court arraignment for violating restraining order. Well, if the alleged victim is next to you while you're filming, harassing her, clearly Kate's not the one doing the harassment. So I hope you guys found that as funny as I did. With that, I'm going to go to bed. It's 1 a.m, and I'm going to be summoned next door to watch monsters open Christmas presents at an ungodly hour. So thanks for joining me. Merry Christmas. Like and subscribe, do all that fun stuff, and I will see you soon.